Let's talk about our template for contempt. Holding someone in contempt can be so fun. Hopefully you never have to, but in reality, sometimes people don't do what the judge has ordered them to do, and so we have to file a motion and ask the court to hold them in contempt. Now, you want to give them every chance to do the right thing before you hold them in contempt, and that will help you on your attorney's fees request when you show the court, look, we warned them, they're still not doing right, and now we have had to file a motion for contempt. The two areas that are most common to file a motion for contempt, one is child support, failure to pay child support. The other is custody and complying with the custody order. So let's say that mom was supposed to get the child on 6 o'clock on Friday and dad just refused to provide the child to mom. Then you might have to file a motion for contempt. But this is a very serious request, because when you're asking the court to hold someone in contempt, it is a quasi-criminal action. So, and they could go to jail in certain circumstances. So you have to really dot your I's and cross your T's before a court's going to do that. And the judge has to very seriously look at the details and the procedure. It's a very procedural area. So you definitely want to make sure you're doing everything technically correct. There's not a lot of room for the court to vary from the procedures that are necessary. So, one thing to note is you have to serve the person that you're asking to be held in contempt personally. And that means their person on their body. A person has to have eyeball-to-eyeball contact with them and hand them the motion for contempt, even if they have a lawyer. And that's different than our normal practice. So for other motions, if they have a lawyer, the lawyer can accept service. But the lawyer cannot accept service. And they'll try to trick you. And they'll say, oh, sure, I'll accept service of that. You don't need to serve him or her. Don't be tricked. They cannot do it properly. So if you want them to be held in contempt, you need to have a process server or the sheriff go personally hand it to them. So you want to have a court reporter if one is not provided. Now, in most courts, one would be provided because this is a final trial, so it would be unusual not to have a court provide one, but please note you have to have one because a record must be made. So also, you'll see in our template we have a category called pleadings. So you must specifically quote in your pleading, so this is your requested relief, your motion for contempt, what order language they have violated. So if it's child support and they were supposed to pay on the first day of every month starting on April 1st of 2013 and they didn't pay for April, May, and June, you can't say something broad like they're supposed to pay child support every month and they didn't. You have to list every date that they were supposed to pay and they failed to. And you should quote, literally in quotes in your pleading, the order language that they violated. So the order language, let's say it's in a decree of divorce and it says so-and-so was ordered to pay on the first day of every month starting July 1st. You would list all that exact language in quotes in your motion, and then you would list specifically every single time they've missed. If they missed 20 months, you're going to list each month individually in your pleading. And that seems silly, but that is required, so you have to do it very specifically. And you must have a commitment order with you. So the court can't order someone to jail but not have a commitment order. And they're going to, if they do order them to jail, which they don't always, of course, sometimes they give them a warning, sometimes they say pay, and if you don't pay, then you're going to jail, so they're basically suspending the sentence. But in any case, even if they do that where they're suspending the sentence, you have to have a commitment order. The court, otherwise the court cannot do it because they have to be able to do something with them. They're going to be standing there needing to be sent off to jail perhaps. So you want to have the commitment order with you. So that's different than just having an order like you might in another hearing giving you the relief. You need to have the order giving you the relief and the commitment order that commits them to jail. Okay, so proof elements. So when you're putting on your case and you're putting on your proof, one of the things that we're going to have to consider is, was the underlying order that you're trying to enforce specific enough? If you're not sure, and frankly there's no harm in doing this in every single case, is include in your pleading a request that the court clarify the order. if it's not specific enough. So you're going to say, we believe it's specific enough and it was crystal clear that Joe Bob or Sue was supposed to pay their child support on April 1st. But court, if you don't think it's specific enough, please clarify it. So that would be your alternative relief, so to speak. The second element is that whatever they were ordered to do must be in writing. Now, let me give you an example where that sounds obvious, but let me give you an example of where it might not. Let's say in your last hearing in open court, the judge ordered the other party to do something, but no one had a prepared order, even though I advised that. No one did. And no order has been submitted yet. So in open court, they were ordered to do it, but nobody has put it in writing yet. That's a problem because it must be in writing. So you want to have your prepared order, but sometimes the judge will not accept it. Their ruling is very different from your prepared order. You want to quickly get that order entered so that if you do need to hold them in contempt, you have an order in writing. Okay, so a tip. We have standing orders in many counties, as you know, and there's a debate of whether or not that standing order is adequate to hold them in contempt. And we have some judges who believe the standing orders are specific enough and some who do not. So it's going to be specific by judge. So you certainly can make the argument, but just be aware some believe it is not contemptible. And the reason for that is the standing order, it is very specific that the party should or should not do certain things. But of course, it doesn't have your client's name in it because when they drafted the standing order, it applies to every case. So if you have a specific concern that the other side is going to do something and you're very concerned about it, it's something that would be covered by the standing order, your best practice might be to enter a temporary order that is specific with your party's names in the order that has the same language as the standing order. Now, I wouldn't do it in every case. I mean, that's the whole point of the standing orders, that we don't have to go get temporary restraining orders in every case anymore. But if you knew there was something serious in that particular case, you might consider doing that. Otherwise, it might, depending on your judge, not be something you can hold them in contempt for. That doesn't mean you can't enforce it. There's a difference, of course, between enforcing an order and holding someone in contempt. But your remedies are broader. If you can hold them in contempt, you may be able to put them in jail. You're not going to be able to do that on just a motion to enforce. So you also, third element that you're trying to prove, because this is, think of it kind of like mock trial days when you're doing elements of proof on a criminal case, you must prove beyond a reasonable doubt that they violated the order and that they had willful intent. So when you're preparing for your hearing, you want to think about how do you show they violated the order and how do you show willful intent? Well, one way that you can show they violated the order is to have a witness. So let's say that it's a circumstance like we talked about before where mom was supposed to bring the child back to dad at 6 o'clock on Friday. The order's clear. That's what's supposed to happen. Mom didn't. Maybe dad's supposed to pick up at mom's house. Dad shows up. 6 o'clock, he's there. He rings the doorbell. No one's home. Well, if you don't have a witness, now it's your client's word against her word. And, you know, sometimes in family law cases, people don't always tell the truth. So if you know that this is happening or it's a repeated offense, you might want to secure your proof by having a witness, just a friend is appropriate, of dad's as he's showing up at mom's house at 6 o'clock. So now you have a witness to say, yep, 6 o'clock we were there, we rang the doorbell and nobody was there. And you have more than just your client's word. So that would be a way to show it. Now, willful intent, that can be assumed in circumstances where the order is clear. But if you had something like mom wrote dad an email and said, of course I wasn't there because I told you we weren't going to be there because we had XYZ activity and I'm not giving her to you until after that. Well, that would be excellent, right? That would definitely show willful intent. But it may be enough just that you were there at 6 and she didn't show up. So you would still go forward, but you might want to encourage your client to communicate with her or him and say, hey, why didn't you pay child support? Why didn't you show up? What's the deal? And maybe you'll get even better willful intent evidence. Okay, so one thing to know is there's other ways people could be held in contempt. You can be held in contempt because you acted poorly in the courtroom. So let's say that a lawyer, certainly not you, but some other lawyer just had a fit and said something horrible to a judge, either in chambers or in the courtroom. The judge right there can hold them in contempt. And in that circumstances, one thing to be aware of is lawyers, clerks, court reporters, and judges, there's special rules for us. So if we are held in contempt, we are allowed to move the court to release ourselves. So let's say that I did something horrible in the courtroom. I would never, but let's say I did. And I can ask the court on my own motion, I can make an oral motion, I can write it out by hand as I'm sitting there, to release me on my own recognizance. And you don't have to go get booked. So that's something to be aware of and to make your everyone in your office aware of. And the officer, so we're talking about lawyers, clerks, court reporters, so on, is allowed to have a hearing with a different judge. An administrative judge would appoint that judge to determine if you're really going to be held in contempt. So that's a special tip. If you have any hotheads in your office, pass that on to the hothead. Okay, so let's say you're at the hearing and the respondent does not show up. Well, they can't hold them in contempt if they don't show up. It's not like a default. You can't default to contempt. What you do is you issue a capias to have them picked up by the sheriff. Then the sheriff brings them there, and then you have the hearing. So don't try to prove of a default contempt. You can't. But what you can do is have them picked up with a capias. So you would need to have a capias there. If you suspect they're going to no-show, go ahead and have your capias ready for the judge to sign. So there's criminal versus civil contempt. And this is a commonly misunderstood area because it's a little bit confusing. But we have a note here in the template that helps to clarify and remind you of the difference. So civil contempt is coercive contempt. In other words, we are putting someone in jail until they comply. So as an example, they may say, you're going to go to jail until you pay your child support that's owing. And the minute that that person pays their child support, they're out of jail. So it's not a defined term. It is coercive, trying to get them to do something. The difference between that and criminal contempt is a penalty. We are penalizing the person. So whether they pay the child support or not, they are going to jail for a definitive term because we are punishing them for their bad action. So it could be, you're going to jail for 90 days or something like that. Because criminal contempt is in the nature of a punishment, there are higher due process requirements. So you want to be aware of that as you're preparing for your motion for contempt.